Imagine this, you speak up at work, maybe you report discrimination, harassment, unpaid wages, or unsafe conditions. Instead of fixing the problem, your boss cuts your hours, passes you over for promotion, or even fires you. That makes you wonder, can my employer legally retaliate if I file a complaint? The answer is no. Under U.S. law, retaliation is illegal. In fact, it's the single most common type of charge filed with the Equal Employment Opportunity Commission, EEOC. Employers cannot punish you for asserting your rights, whether that's filing a complaint, participating in an investigation, or simply speaking up about workplace violations. In this video, we'll break down what retaliation really means, the laws that protect you, common examples, and what you can do if it happens to you. Part 1. The legal definition of retaliation. Retaliation happens when an employer takes negative action against an employee for engaging in a protected activity. A protected activity is any action you take to assert your workplace rights under federal or state law. Protected activities include filing a discrimination or harassment complaint under Title VII of the Civil Rights Act, requesting accommodation for a disability under the ADEA, complaining about unequal pay under the Equal Pay Act, reporting wage violations under the Fair Labor Standards Act, LSA, reporting unsafe working conditions under OSHA, taking family or medical leave under the FMLA, participating in an investigation or testifying on behalf of another employee. If your employer punishes you for any of these actions, that's retaliation. The punishment doesn't have to be outright firing. It can include demotion, pay cuts, undesirable schedule changes, denial of promotions, exclusion from meetings, or creating a hostile work environment to push you out. Legally, 3 elements define retaliation. 1. You engaged in a protected activity. 2. Your employer took an adverse action against you. 3. There's a connection between the two. The EECC looks closely at timing. If you filed a complaint and were fired 2 weeks later with no clear explanation, that timing is strong evidence of retaliation. It's important to note, the law doesn't protect you from all consequences. If you engage in misconduct or violate company policy, your employer can still discipline you. But they can't use a complaint as the reason for adverse action. In short, retaliation isn't just unfair, it's illegal. Federal law protects workers from being silenced when they stand up for their rights. Part 2. Common forms of retaliation in the workplace. Retaliation doesn't always look obvious. Sometimes it's dramatic, like being fired right after you file a complaint. But more often, it shows up in subtle ways that make your work life harder, pushing you to quit. Here are some of the most common forms. 1. Termination or demotion. The most extreme form of retaliation is losing your job or being moved to a lower position. For example, a worker reports racial discrimination and is suddenly reassigned to a lesser role with a pay cut. If the timing matches the complaint, that's classic retaliation. 2. Pay cuts and lost hours. Your employer may not fire you, but instead cut your hours, deny overtime, or reduce your pay. Imagine filing a wage complaint under the Fair Labor Standards Act, FLSA, only to find your weekly schedule slashed in half. That's retaliation. 3. Promotion denials. Retaliation can also mean quietly blocking career growth. If you were on track for a promotion, but after reporting harassment, you're passed over without explanation, it could be retaliation, especially if less qualified coworkers advance instead. 4. Harassment or hostile treatment. Sometimes retaliation takes the form of daily harassment. Your boss may criticize your work unfairly, exclude you from meetings, or assign you unpleasant tasks as punishment for speaking up. Courts recognize that creating a hostile work environment to drive someone out is retaliation. 5. Blacklisting or threats. In some industries, employers retaliate by bad-mouthing former employees to prevent them from getting new jobs. Threats of reporting immigration status or spreading false rumors can also count as retaliation under federal law. 6. schedule or duty changes. Even if your job title doesn't change, retaliation can happen through sudden schedule changes, like moving you to the night shift when you've always worked days, or giving you physically demanding tasks to make your life difficult. Real examples highlight these patterns. In one case, a hotel worker who reported sexual harassment was reassigned to clean more rooms than anyone else, a clear punishment for speaking out. In another, a warehouse employee who reported safety violations under OSHA was fired within days. Both workers won retaliation claims. The takeaway: retaliation isn't just about losing your job. It's any negative action designed to punish you for exercising your rights. Knowing these patterns helps you spot retaliation early and take steps to protect yourself. Part 3. How the law protects workers from retaliation. The good news is this: U.S. law has strong protections against retaliation, and they apply across many different workplace rights. Let's break down the key laws that shield employees. Title VII of the Civil Rights Act of 1964. This law prohibits retaliation against workers who complain about discrimination based on race, color, sex, religion, or national origin. If you file a complaint, testify, or even participate in an investigation, your employer cannot legally punish you for it. The Americans with Disabilities Act, ADEA. The ADEA not only bans disability discrimination, but also protects workers who request reasonable accommodations. If your boss retaliates after you ask for modified duties or flexible scheduling, that's unlawful retaliation. The Age Discrimination in Employment Act, ADEA. Workers over 40 are protected from retaliation when they report age-based discrimination. For example, if you complain about being passed over because you're too old and then get demoted, that's retaliation under the ADEA. The Equal Pay Act, EPA. If you speak up about pay inequality between men and women, you're protected from retaliation. Employers can't cut your hours, deny promotions, or terminate you for raising pay concerns. The Fair Labor Standards Act, FLSA. This law covers wage and hour rights. If you file a complaint about unpaid overtime or minimum wage violations, your employer can't retaliate. Even informal complaints to a supervisor count as protected activity. The Family and Medical Leave Act, FMLA. If you take job-protected leave for childbirth, illness, or caregiving, your employer cannot punish you for exercising that right. Retaliation includes firing, demotion, or discouraging other employees from taking leave. The Occupational Safety and Health Act, OSHA. Workers who report unsafe working conditions or refuse dangerous tasks are protected. Employers cannot fire, harass, or blacklist employees for raising safety concerns. Whistleblower protections. Beyond these, many federal and state laws protect employees who report fraud, corruption, or violations of law. Retaliating against whistleblowers can result in heavy penalties for employers. What all these laws have in common is the principle that workers should be free to assert their rights without fear. If employees were too scared of retaliation, laws against discrimination, unsafe conditions, or unfair pay would be meaningless. That's why retaliation is illegal, and why it's the most frequently filed charge with the EEOC. Part 4. What to do if you suspect retaliation. If you believe your employer is retaliating against you, don't wait. Taking action quickly is the best way to protect yourself. Here are the key steps. 1. Document everything. Write down every change in your work situation after you filed a complaint. Keep track of dates, times, and details. Save emails, texts, schedules, or memos that show your hours were cut, your duties changed, or you were disciplined. If your performance reviews suddenly drop without explanation, keep copies. A clear timeline is powerful evidence. 2. Compare treatment. Look at how your coworkers are treated. If others who didn't complain keep their schedules, promotions, or pay, but yours changed, that contrast strengthens your retaliation claim. 3rd, report internally again. If it feels safe, report the retaliation to HR or management in writing. State that you believe you're facing retaliation for a protected activity. Employers have a legal duty to investigate, and documenting your concerns creates another layer of protection. 4. File a complaint with an agency. Depending on the situation, you can file with the EECC for retaliation linked to discrimination, harassment, or accommodations. The Department of Labor for wage and hour issues under FLSA or leave rights under FMLA. OSHA for retaliation tied to safety complaints. Deadlines are short, often 180 days, and sometimes as little as 30 days for OSHA complaints. Act quickly to avoid missing your window. 5. Seek legal advice. Employment lawyers can help evaluate your evidence, file claims, and negotiate settlements. Many work on contingency, so you don't pay unless you win. Lawyers can also guide you if you receive a right to sue letter from the ECC, which gives you 90 days to file a lawsuit. 6. Know your remedies. If retaliation is proven, you may be entitled to reinstatement, back pay, compensatory damages, punitive damages, and coverage of attorney's fees. Courts may also order employers to change their policies and provide training to prevent future retaliation. The most important thing is this: don't suffer in silence. Retaliation thrives when employees feel powerless. By documenting, reporting, and using the law, you can fight back. And many workers do succeed. Part 5. Real-life examples of retaliation cases and key takeaways. Sometimes the best way to understand retaliation is through real cases where workers fought back and won. These examples show how the law works in practice. Example 1. Sexual harassment complaint. A hotel worker reported repeated sexual harassment by her supervisor. Instead of protecting her, the company reassigned her to a heavier workload and later fired her for poor performance. The EEOC sued, and the worker received back pay and damages. The company was also forced to change its harassment policies and train all managers. Example 2. Equal pay complaint. A female sales manager discovered she was being paid significantly less than her male counterparts. After she complained, her employer cut her accounts and reduced her commissions. She filed a retaliation claim under the Equal Pay Act, and the court awarded her both lost wages and punitive damages for the employer's bad faith. Example 3. Safety concerns. A construction worker reported unsafe scaffolding to OSHA. Within days, his employer fired him, claiming there wasn't enough work. OSHA found this was retaliation and ordered the company to reinstate him with back pay. This case highlighted why workers shouldn't fear speaking up about dangerous conditions. Example 4. FMLA. Leave. An office employee took Family and Medical Leave Act, FMLA, time to care for a sick parent. When she returned, she was demoted and given meaningless tasks. She filed a retaliation claim, and the employer had to restore her job level and pay damages. From these cases, we can draw key takeaways. 1. Retaliation is the #1 most common workplace complaint filed with the EEOC. 2. It often looks subtle: shift changes, workload increases, or sudden negative reviews. 3. Timing matters. If adverse actions come right after a complaint, agencies and courts see that as suspicious. 4. Workers who document and act quickly often win back pay, reinstatement, and changes to company policies. The lesson is clear. Retaliation is not just unfair, it's illegal. And workers who stand up have strong protections under federal and state law. So, can your employer retaliate if you file a complaint? The law says no. Retaliation, whether it's firing, demotion, pay cuts, or subtle harassment, is strictly illegal under laws like Title VII, the ADEA, the FMLA, OSHA, and the FLSA. Employers are not allowed to punish workers for standing up for their rights, reporting violations, or helping others do the same. If you suspect retaliation, the most important steps are to document everything, act quickly, and use the the protections available through the EEOC, CEOSHA, or the Department of Labor. Many workers who spoke up have not only won back pay and reinstatement, but also forced companies to change unfair practices. Remember, your voice matters. By reporting retaliation, you protect yourself and help create safer, fairer workplaces for everyone. If this video gave you clarity, hit like, share it with someone who might need it, and subscribe for more plain English guides to workplace law.